So you filed your trademark application on your own because you thought by doing so you might be able to save a little bit of money. And now you just got an office action telling you that you can amend to the supplemental registry? What? Now there's a number of reasons why this could have happened, but the number one reason that people get asked to amend their application to the supplemental registry is because the attorney that's examining your file deems that your mark is what they call merely descriptive. And because it's merely descriptive, it hasn't acquired sufficient distinctiveness in the marketplace yet to qualify for registration on the principal registry. Now before I go any further, most people don't know there is actually a distinction between the principal registry and the supplemental registry, and we're going to talk about that today. Specifically, we're going to talk about what exactly the supplemental registry is. Is it bad? I mean, is it bad to be getting something asking you to put your trademark application on the supplemental registry? What should you do if you get one of these office actions asking you to amend? Should you just give up? Do you need an attorney? All great questions. Let's roll the intro and we'll get into it. Hi, I'm Jim Hart. I am a trademark lawyer. If you're new to the channel, we talk about tips and strategies and things that you need to do to protect your business legally so you can grow an amazing brand, live the life that you want, when, where, and how you want, and achieve financial independence. And today I want to be talking to you about something that comes up quite frequently, especially with people who try to DIY their own trademark applications, and that is they get asked to amend their application to the supplemental registry. Now, most people are not aware, but there are actually two registries for the U.S. Patent and Trademark Office. There's the principal registry, which is what most people are seeking when they're registering their trademarks at the USPTO, and there is the supplemental registry, which is another kind of parallel database of marks that is also at the USPTO. Now, there are a lot of benefits of having your mark on the principal registry that don't necessarily translate to the supplemental registry. And so let's go through those real quick. But we're gonna wait for this plane to fly by before we do, because I live in the flight path, if you weren't aware of that, and we get a lot of planes. First benefit of registering on the principal registry is that you will have what's called prima facie evidence of your exclusive right to use the mark. You don't get that on the supplemental registry. And I know that sounds confusing, and a lot of people have no idea what I just said. Suffice it to say, basically when you're talking about prima facie evidence, that means that it's a burden if you have to go into federal court, which basically means that if you have to go into federal court on an infringement lawsuit with a mark that is registered on the supplemental registry, you have to prove that you have the exclusive right to use that mark, which basically is a higher standard of proof. With the principal registry, you just get it. I don't even know if I'm gonna keep all this in this is complicated. All right, the second benefit of the principal registry is that you get constructive notice. I'm actually gonna read this because this is also another mouthful. Constructive notice of a claim of ownership so as to eliminate a good faith defense in an infringement lawsuit. So basically what that means is that when you have a mark that's on the principal registry, somebody else can't say, well, wait a minute, hold on, I did not know that this mark was registered, so in good faith I thought I could use this mark. That's basically what that means. If you register on the supplemental registry, the person that maybe is infringing on your mark can raise that good faith defense, but you can't do that if your mark is on the principal registry. Excuse me, the principal register. All right, the third benefit of registration on the principal register is that after 5 years you can file what's called a notice of incontestability, which means that your mark at that point is basically rock solid. Nobody can steal it from you, nobody can cancel it, or it would be very, very, very difficult for them to do that. And the last major benefit to having your mark registered on the principal register, which is going to be especially helpful to those of you that are importing goods for China as e-commerce sellers, maybe on Amazon or Shopify or someplace else, is that if you have a trademark that's registered on the principal register, you can then take that trademark and file it with US Customs, which will then stop the importation of goods that may violate your trademark or may infringe on your trademark. That is not something that's possible on the supplemental registry. Why do I keep saying registry? I don't I don't know why I do that. It is the Supplemental Register and the Principal Register. If you have a trademark that's registered on the Supplemental Register, you do not have that benefit to stop the importation of infringing goods. Now that we've gone through all the benefits of the Principal Register, let's talk about the benefits of having your trademark register on the Supplemental Register. And of course, all of these benefits also apply if you're on the Principal Register, but I don't want you to think that the Supplemental Register is bad, because we've talked about a lot of benefits for this principal, but that doesn't mean that the Supplemental Register is bad, and don't forget about it. Why am I mumbling and talking so much? Before we do that, I think I need to, you know what time it is. And by the way, as I'm drinking this coffee, I always like to do a little interjection here. I apologize that we've got the dog crate in the corner. Cheers. Let's talk about the benefits of registration on the Supplemental Register. The number one benefit is that your trademark on the Supplemental Register can still be used to bring an infringement action in federal court. You're going to have some additional hurdles that you're going to have to cross once you get into court, but you can use that registration on the Supplemental Register to bring an infringement lawsuit in federal court should you need to do that. Right, the second major benefit of having your trademark on the Supplemental Register is that it can be cited by the USPTO to deny a newly filed application for a mark that would be the same or deceptively similar to your trademark. The third major benefit of registering on the Supplemental Register is that your mark is still going to be found in standard USPTO searches. So if you go to the USPTO database and you're looking for marks that might be deceptively similar to your mark, and if you're doing a trademark search, then this mark that's on the Supplemental Register will still show up in the USPTO database to help deter people that might be looking to register a name that's deceptively similar to yours or likely to cause confusion with your name. So you can still use it to stop people from stealing or trying to register names that are going to be too similar to your name. The fourth major benefit of the Supplemental Register is you can still use the R with the circle around it symbol. You know what I'm talking about? That one. You can still use that symbol behind your name to show people that you have a registered trademark, even though it's on the Supplemental Register. And the next benefit, I'm not sure this is really qualifies as a benefit, but it's kind of the way the practice works, is your mark does not have to go through the publication process. And I've talked about this before because in about 1% of the cases, a mark that gets published for opposition may draw actually an opposition proceeding from another trademark holder. And so by bypassing that publication period, you are eliminating the possibility that somebody can oppose your mark during publication. However, if there was someone out there that was likely to oppose your mark, then they're probably paying attention, and after your mark registers, they can then bring a cancellation proceeding against you. So it's kind of a benefit, but at the same time, it's kind of a double-edged sword, because on the one hand, they're not going to get you during the publication period, but then they can just file a notice of cancellation or a petition to cancel your trademark after your trademark registers. And then the last main benefit is, you got that office action because the trademark office said that your mark was merely descriptive and it had not yet acquired distinctiveness in the marketplace. After 5 years of continued and exclusive use of your trademark, provided you can show evidence to the trademark office that you have been using your mark continuously in practice, then you can go ahead and file a new application to register your mark on the principal registry after 5 years. And so that is kind of a benefit. So even though at the very beginning you're on the Supplemental Register, after 5 years you have a path to moving your mark onto the principal register if that's something that you would like to do. Big question, should you amend to the Supplemental Register if the examining attorney asks you to do so? Well, typically they're going to tell you that you can either respond to the office action or you can amend to the Supplemental Register. And it's really up to you. So I would say if you're not sure what to do in this situation, you need to talk to an attorney. You need to talk to a trademark attorney. We do offer free discovery calls with our clients. There's a link down in the description below if you'd like to schedule a call with me. We're happy to talk to you about your options in terms of whether you should file a response to the office action or amend to the supplemental registry. So bottom line is the principal registry, why do I keep doing that? The principal register is better, but that does not mean that the supplemental register is bad. Many of the major benefits that are tied to having a registration on the principal register are tied to lawsuits in federal court. So most people do not end up in federal court in a trademark infringement lawsuit, especially once you have a registered trademark. Unless you are a big multinational company, you're probably not going to be filing an infringement lawsuit because they cost hundreds of thousands of dollars to prosecute. That's not to say that you will never end up in federal court, but it is highly unlikely for most solo and small entrepreneurs like the people that are watching this channel, like you lovely people. The main benefits for registration and what I talk to my clients about are, number one, you want to be able to use your trademark without worry that you're going to get a cease and desist letter from another business telling you that you're infringing on their rights. You get that by having your mark on the supplemental register. And number two, the fear and worry that comes from thinking that somebody else is going to come in behind you and register a mark that is likely to cause confusion with yours, or then ultimately ask you to stop using your mark. You also get that benefit of not having somebody able to do that if you have a mark on the supplemental register. This is Ginger. I don't think I've ever introduced you, Ginger. Can't believe she let me pick her up for that. So basically, all the benefits that I talk to my clients about why you want to have a registered trademark are still present if you are on the supplemental register. And you just don't get those protections if you end up in federal court if you are not on the principal register. So if you'd like to learn more about protecting your brand with a federal trademark, here's another video I did right here that talks more about how to go about registering your trademarks. Thank you for watching today, folks. I'll see you in the next video. Take care.